মেনশন করবেন তো আপনি আর একটু হ্যাঁ নিশ্চয়ই আমি সিনিয়ররা করবে তবে তো আমরা করি
কপিটা পেলাম না
রেডি হইনি এখন
Yesterday leave was given and the matter was directed to be tagged with item number 4. Only one difference, these are the para teacher. They are exempted from the category of they are the 10% reservations they are coming, and aptitude test is that they are exempted. I have written this, let it be taken. These are kindly take note of it. Same adopted, same argument, only the 10% reservation category and aptitude test is exempted. Exempted for the para teacher category. Get
Lordship, may I be permitted to file the memorandum of appeal without certified copy because your Lordship, the learned single bench on 27th April directed the appellant hearing, the school authority to allow the respondent hearing, the teacher to ঠিক আছে without certified copy, your Lordship.
Similar prayer. My lord,
Yeah.
similar prayer.
Lordship, I crave leave to file an appeal from the original order, Lordship.
Without the certified copy.
Yes, Lordship.
Leave is being granted to the extent to file
Yes, Lordship.
without the certified copy.
Without the certified. May I give?
Lordship.
despite the huge pressure upon Lordship's board,
Yes.
may be permitted to mention a matter. Item 149, shortest possible appeal, my lord. My lord, only question is payment of interest on late payment of gratuity. My lord, case is pending since 2013. The petition is about 75 years old, my lord. Appeal is of 2013. Well, it will not take much of a lordship's time, my lord. Only interest on gratuity, late payment of gratuity.
After the vacation, not
My lord,
this side.
lordship will kindly fix any day after the vacation.
We will fix it. Ask your learned junior to remind us after the court reopens. If this bench is sitting, we will appreciate it. Yes,
My lord, in that case, I shall personally come and mention.
very good. After the vacation.
May I permitted to mention non-prosecution?
Lordship, may I permitted to mention matter, Lordship. Lordship, kindly leave granted, Lordship, one matter, Lordship. On 16th May 2023, the Hon'ble single bench passed an order, Lordship, in Bobita Sarkar matter, Lordship. Kindly, there is a grave urgency, Lordship. Kindly grant leave, Lordship. Lordship, this matter, Lordship, without I am filing the memorandum of application, Lordship, without certified copy and without the server copy, Lordship. Kindly leave granted, Lordship. Lordship, kindly and fix a date, Lordship.
Without the server copy also.
Yes, my lord. Yes, my lord. I am leading, my lord. Server copy because, my lord, server is not working till, my lord, 2-3 days, my lord. We cannot download from that website, my lord.
Right.
My lord, gist of the order is there, my lord.
Leave is granted. Leave is being granted to the extent that you may file.
Lord,
But
kindly fix the date, my lord. There is some urgency, my lord, because my lord, his service is
without-
terminated, and my lord, he has to submit, my lord, amount of 11 lakh within, my lord, 3 days, my lord.
Lord Counsel, without the server copy,
My lord, gist of the order is there, my lord. It is, the verdict is given, my lord, in open court. Gist of the order is there, my lord. Well, I will-
What is the gist of the order? Everybody has an urgency of everything. Last evening we were here. Every time you come running with an urgency. Do we not have to deliver some orders and sit down and do some homework? What is the order? When was the order passed?
my lord,
Show us the order, gist of the order. This is that Bobita Sarkar matter.
Yes, my lord.
You are now saying it's an urgency. Come back after filing the application and then we will list it.
My lord, this is my lord Bobita I am mentioning my lord Bobita Sarkar.
That's right. You come back, we give you leave, come back and then then we will list it according to our convenience.
When I was mentioning the transfer matter, maize to fruits. But can I
No,
bring the
leave-
other side?
Leave to the.
Can I bring the other side at 2 p.m. my lord? That maize, the pay has been stopped, my lord. Although she is teaching classes.
This court is not available. We are delivering a judgment. We are working on that. 2 p.m. this court is not available. Try your luck tomorrow morning.
But can I bring the other side tomorrow when
Try your luck. Rakun.
I'm obliged?
You please, Mrs. Vishwas, you are granted leave to file the matter. And after you file the matter, you give the number with your urgency. Please follow that procedure. We will look into it.
Yes, my lord.
But according to the convenience of the court.
Grateful, my lord.
My lord, Mr. Ochinto Banerjee, appearing on behalf of the university, is engaged in courtroom number 15.
Take it.
I seek a nod today, my lord.
My lord, last occasion, my lords were pleased to pass certain directions. Now, my lord, I find, my lord, that one of the points which was taken, that appointment given to persons even below 15. My lord, I only submit that having regard to the facts that I have got documents to the effect that, my lord, admittedly the persons who had been given appointment, who are identically placed like me, my lord, I may be permitted to bring those on records by way of filing a supplementary
This
affidavit.
is a date of birth matter.
That.
No, why? We'll hear you. We'll hear you.
I'm good. I'm good.
When can you address this court? After vacation, we'll give you a date. When can you address this court?
15th, my lord. 15th, my lord.
Why so far? Why so long?
My lord, I have been instructed.
Ask him to come and instruct you. Why so long?
My lord, any day after vacation.
হ্যাঁ, জজই নিজে বলে যে তোমার যে বলেই তো দিল।
ভালো জাজ না, পিছিয়ে ঘর থেকে সরাতে অ্যাভয়েড করতে চাইছি।
পাঠাট করে পাঠাট করছে
জুলাই মাসে
এখন এই কথাগুলো ছেড়ে দেন। হ্যাঁ, হয়েছে তো।
8th of June. 8th of June, 8th.
I'm grateful.
We have heard this matter for several dates. We'll treat it as heard in part.
I'm grateful.
Oh, he has come. He has come. Yes,
Leaving my lord the phone matter
no.
going on, my lord. I have come. Yes.
yes. Start. Take your seat, Mr. Banerjee. Take your breath. Take your seat. Yes.
My lord,
এটা কিসের বই?
my actual date of birth, my lord, your lordship has passed an order, my lord, wherein, my lord, your lordship has given all observations. But only thing I just indicate to my lord that the actual date of birth is 19/8/1956. Recorded date of birth is 28 June 1954. Then my lord's meeting of the grievance redressal cell that was made on 3rd of July 2023. That my lords will be pleased to find at page 42 to 47 of the stay application. Now, my lord, in page number 45, it was recorded, my lord, that the to consider the application dated 26/2/2013 of Sri Ashish Kumar Banerjee, Junior Superintendent, requesting to rectify or change his date of birth as 19/8/1956.
Which
Instead
page?
of-
Which page are you reading?
My lord, I am reading from page 45, which contains the particular, my lord.
Of which can application?
This is can number 2015.
We
Where
do not,
my lord, a prayer for application for interim order.
do not have 45 pages. এটা দেখান।
Possibly, my lord, it would be from the stay petition itself, my lord. This is application for interim order, yes. Application for interim order. Page 45. কি কানেক্ট কি অ্যাপ্লিকেশন এটাই তো 1956 to 2030, requesting to rectify or change his date of birth as 19/8/1956 instead of otherwise recording the date of birth in the university. Then Millard, it was observed that the date of birth of Ashish Kumar Banerjee was recorded in the university register as 26/1954. Personal file of Sri Banerjee, no authenticated document regarding his date of birth could be found. Sri Banerjee way back in 1997 submitted similar type of representation requesting to record his date of birth as 19/8/1956 on the basis of admit card of higher secondary examination of 1975 issued by the West Bengal Board of Secondary Education, but no action in this regard was taken at that time. Now he has submitted the same prayer requesting to record his date of birth as 19/8/1956 on the basis of the admit card of higher secondary examination 1975 and certificate issued by the West Bengal Board of Secondary Education. After careful consideration of the entire matter, the GRC recommended that the prayer of Sri Ashish Kumar Banerjee may be considered subject to verification of his date of birth from West Bengal Board of Secondary Education. 19/8/1956, which was recorded. Now, corrected date of birth. Now, Millard, if found in order, his date of birth may be recorded as 19/8/1956, subject to final approval of the EC Executive Committee. At the time of discussion and adopting resolution, say Ashish Kumar Banerjee, representative of this Bardhaman University, was requested to stay away from the meeting temporarily because the matter is related to him and he remained temporarily absent during this particular period. And your Lordship has taken note of it. I am grateful to my lords that the RTI query on the next annexure, Millard, which was obtained by Ashish Banerjee, indicates that these persons, Akash Kumar Chatterjee and Anupam Kumar Hajra, their name was also recorded long after Millard, their entry. Therefore, Millard, there is no impediment to consider, Millard, the
So how could you
actual
enter service when you were a minor?
Millard, yes.
How could you
Millard,
enter
I'm
service
grateful.
when you were a minor?
I'm grateful. আগে ইয়েটা দে Millard, 1 second, Millard,
লিস্ট এটা হচ্ছে সিনিয়রিটি লিস্ট
হ্যাঁ।
যেখানে সবার ডেট অফ পোস্টের ডেট অফ বার্থ লেখা আছে
হ্যাঁ।
এবার দেখুন ঠিক আছে
এটা হচ্ছে তাপস চট্টোপাধ্যায় আর যারা যারা আছে আর 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 একটু বের করে দাও আরেকবার যশোরকে রাইট রাইট Millard, my learned junior has obtained, Millard, a list of seniority of the non-teaching employees of the University of Millard. This was published. Yes. Now, Millard, we had collected it. Millard, the pages have been folded. Millard, I'm sorry, Millard. Kindly excuse me, and I have one copy. I tender my unqualified apology that I could not give. Kindly see the minors' names. Many minors' name, Millard, had been, there is a small, Millard, asterisk mark wherein there is an indication minor. সব দিয়ে দেবো ভাই অ্যাফিডেভিট আমি পুরো এটা দিয়ে দেবো আচ্ছা এবার আমাদের এখানে যে এন্ট্রি না আমি আমাদের যে ছিল করা হয়েছিল সেই রুলসটা কি আছে যে ঠিক আছে এইটা থেকে
পরের কথাটা পরের কথাটা আর একটু কথাটা এখানে কিভাবে ইউনিভার্সিটিকে দেখিয়ে জিজ্ঞেস করতে হবে। He was appointed to a Group D post.
Yes. On as extra temporary basis. On extra temporary basis.
Yes.
Post, yes.
So these are similar appointments. Yes, Mr. Banerjee, go through
Yes,
this.
similar appointment. I'm grateful to my
এটা
lord.
দেখো Banerjee সাহেব. Some minors were appointed on that date. What is the instruction?
Integrating government. Shall we record it?
There are asterisk marks. Join the relevant portion here.
আমি দেখিয়ে দিচ্ছি দাদা, এই যে যেখানে যেখানে আছে এই যে আগেরটা একটু দেখিয়ে দিই। এক মিনিট, এই যে এটা মাইনর অ্যাট দ্যাট এজ দেখে নিন, তাপস চ্যাটার্জি। তারপরে এটা এই যে আমি আগে দেখিয়ে নিই, তারপরে আপনি আপনারটা বলুন। Milord, I have one more submission,
He'll
Milord.
come to you after him.
I have one more submission, which I had shown, Milord, that the particular, Milord, the appointment of non-teaching staff under the university ordinance relating to appointment and terms and conditions of service of non-teaching staff. There, I find under age register explanation. Milord, kindly see the এটা হচ্ছে আপনাদের যে রেগুলেশন, কত চুন age registered, then Milord the regulation. না কত 11 আগেরটা মানে যেটা নাকি আমরা and the in terms of a division bench, in terms of the direction passed by a division bench of this court, Milord, we have annexed the birth certificate that is at page 11 of the supplementary affidavit.
Yes. So what do you want to prove from here? From this, what do you want to?
I want to show that, Milord,
At a university.
there is no, yes,
Just tell us what do you want
Yes.
to show.
I want to show, Milord, that I did not find that there was a age stipulation. Age stipulation, that one what I ordinance.
Yes.
Now this particular, Milord, I only suffered, Milord, because I do not want any other benefit. I say that let the actual date of birth. Age register. So, my lord, these are principally my submissions. I say, my lord, that the birth certificate also is a tangible evidence. And now, my lord, it is for my lords, my lord, to decide as to whether. Yes. And my lord, I have also handed over to my lords the seniority list, this list.
Yes, that you're handing over to us.
I handed over to us, then your lordship, my lord, handed over to Mr. Banerjee.
Yes, yes. Give us the seniority list.
একটা seniority list দিয়ে দিন।
Give us
My lord, I am handing it over. I have one copy. I am giving it to Mr. Banerjee. এটা জজ সাহেবকে দিন। হ্যাঁ, এটা দিয়ে দাও।
Yes, Mr. Banerjee.
My lord, first thing, insofar as the documents which they are showing, my lord, in as the seniority list, my lord. But I have subject to further instruction in this regard, my lord. First thing, my lord, your lordship will appreciate whether at this stage,
Original.
my lord, some more documents can be disclosed at appeal stage. Whether this is permissible or not, disclosure of document, number one. Number two, my lord, whether he can, my lord, plead beyond the pleadings made in the writ petition itself. Number three, my lord, I have to take instruction insofar as those persons are concerned. That apart, according what I gathered from my learned friend's submission.
Please take your seat, Mr.
Yes, Lord, I just only want to indicate that I find, my lord, that my client has brought the original from the University of Bordeaux. Original. This is given to all the employees.
What I have gathered from my learned friend's submission, my lord, that those persons were appointed at a minor age and they could get the scale, my lord, only on attainment of majority.
They could get what?
They, Mr. Bhattacharya has
Yes, they were appointed minor age and they
minor age and they got the scale actually.
Yes.
That is to be treated as an employee of the university only after attainment of the age of majority. Here is a difference, my lord, apparently in as much as, my lord, from 1975 onwards, he was appointed in 74. From 75 onwards, he got the scale of pay on the basis of his declaration. And that, my lord, within a span of 1 year, if his date, if the date which was recorded in the university is taken into account, even on that day, that is 1975, he was minor. This is one aspect of the matter. The other aspect your lords will kindly consider, since as it appears from the order passed by my lords on the other occasion, my lord will consider that whether any penal measure or disciplinary action can be taken or not in this regard for such concealment. But the question of concealment would only arise if and only if his corrected date of birth is accepted. My lord may recapitulate. On the other day, I submitted that, my lord, the school final certificate as a private candidate cannot be taken into account, my lord, as a conclusive evidence. And my lord, the certificates, the date of birth certificate from the
school final certificate.
Page number 19.
Yes, my lord, you will also kindly see.
Issued by the West Bengal Board of Secondary Education.
Yes, my lord. Kindly see, peruse, my lord, as a private candidate. My lord has got it, my lord. And these documents, my lord, were subsequently, my lord, tried to be corroborated. Even in the next page, in the admit card, my lord will find that he was a private candidate. He was a private candidate. Now, by way of supplementary affidavit, my lord, they have disclosed a certificate, my lord, from the Register of Birth and Death. My lord will find what is the date. It's of 2023 after the direction given by the Honorable Court, because the other bench, when it was taken up, this document, when this certificate was shown, the division bench did not accept it, and my lord asked them to disclose some clinching evidence, credible evidence rather. My lord will find the date of birth certificate. It's of my lord, subject to correction, my lord, March 2023. After the order passed by after the direction given by the honorable division bench. Now the question would be, my lord, whether such documents which are not contemporaneous in nature can be taken into account or not. Whether at this distant age, my lord, it can be done. My lord, two examples were set that their date of birth have been corrected, had been corrected in the year 1997. There, my lord, I have demonstrated before my lord that as on the date of consideration and taking into account their earlier date of birth, that is the date of appointment, on the date of appointment, my lord, they were major. So correction could be done in that respect. Now, my learned friend has shown, my lord, I am showing, my lord, the ordinances. This is not the ordinances, my lord, ordinance, my lord, which is shown, my lord, in respect there are two. You will also can see I have only, I have a copy. These are the two copies of ordinances, my lord, you will also kindly see. Army. My lord, kindly come to chapter 3. My lord, kindly come to University Ordinance 4 within bracket SR NTU. No person who is below 18 years of age shall be appointed to the services of the university. This is one. Now, your lords will kindly see, since my lords were pleased to ask my lord the query, your lords will kindly take note of Ordinance, my lord, 11. That chapter itself, my lord, Ordinance 11 and 2.
What you have furnished, the ordinance, that
Yes.
is of the date, that is dated 27th June of 2000. 27th June 2000.
This is.
Yes, this one.
No, it's my lord. Kindly.
According to the appellant,
Yes.
he joined the service in the year prior to 1974.
Right. But even then it was there, no, it's not that.
This is this book. I am giving this book. This here, my lord, it starts the ordinance. I did not find any provision from here.
No, no. This is also an ordinance in that regard. My lord will appreciate that this ordinance is also, my lord, a date posterior to that of the appointment of the appellant. Because he was admittedly appointed in 1974. And he is relying upon a document also.
Now the main contention is whether a minor,
but it's my categorical instruction, my
was
lord,
allowed to join the service or not.
No, it's my categorical instruction, my lord. My lord may record it. And if my lord so pleases, my lord, I can put it on affidavit also. That no one could be appointed below the age of 18 years. Because these, in both these, according to my lord's, this is of 2000 and this is of 1983. So both the documents.
As on that date.
Yes.
As on
date. It's both of them are as on, not as on that date.
You have to clarify as on that date.
What was
whether-
what
yes,
was the
what
order?
was the
Yes, well, for that matter, I have,
prevailing ordinance that.
yes,
at
well,
that
for
time?
that matter, I have to take instruction in that regard. I cannot say at the present moment. Because without instruction, it would be difficult for me, my lord, to make any submission. Because so far I was told
Council's supplementary affidavits be provided. You furnish what you have provided today, including that.
let my learned friend disclose, my lord, these ordinances also along with the supplementary affidavit.
Yes, along with the supplementary affidavit. And you will be.
I
at
shall respond
liberty
to
to
it.
file the.
I shall
reply
respond to it, my lord.
Yes,
Upon receipt of that, I shall respond to it.
Within this interregnum vacation, my lord, I will be handing over it to Mr. Banerjee's client or to Mr.
It
Banerjee.
would not be possible, my lord, because I'll
Within
not
the
be
week
here.
after the vacation, within
Yes,
the week
yes,
after the
yes,
vacation.
yes, I
And-
say. At
My
the
lord,
earliest,
my lord,
your
my lord, if my lord, my learned friend tries to serve it upon me during this interregnum of this vacation, but I'll not be available because I'll not be here. I shall be my lord, in my native
Very well, I
place.
will serve it by tomorrow. I will serve it by tomorrow. I will prepare it. I will serve it by tomorrow.
Very well.
আমি এখনই বসে আমি করে দিচ্ছি because I have much of time.
Mhm. The Delaware Council appearing before the applicant.
That list may also be disclosed, my lord.
Everything. I will disclose this. list.
Whatever has been disclosed today,
Yes.
the entire be disclosed in the
list,
affidavit
the
within Learned Council,
Yes,
within 1 week after the vacation, and thereafter you will get the opportunity to furnish the reply within 1 week thereafter. And the matter will
My lord,
appear.
at least 2 weeks, my lord. Otherwise, from university, it would be difficult to get it. My lord will appreciate my difficulty, my lord. There are other works.
Maybe
And in any event, one thing I can say, there is no urgency in this sense that even if the modified date of birth, which has been furnished by my learned friend, is accepted by this honorable court, he would not be able to join the duty.
He also furnishes a seniority list wherein there is mention of appointment of minor. Wherein there is mention of appointment of minor. Full stop. The appellant is given the liberty to furnish all the relevant documents which he intends to file along with supplementary affidavit. Supplementary affidavit. Okay. Within 1 week after the summer vacation. and the university of Bardhaman University is at liberty to file opposition to the same within 2 weeks thereafter. After the affidavits being exchanged, the parties shall be at liberty Learned councils,
But matter will,
within 1 week after the vacation. Thereafter, you are at liberty to file the reply within 2 weeks thereafter. And after the exchange of affidavits, let the matter be mentioned.
My lord, if it is mentioned, my lord, may I just only make one little prayer before my lords? My lord, I know, my lord, the inconvenience of the court. But I can appeal to the court, my lord, that your lordship may kindly fix up any date on which, my lord, I will be doing it. I say, my lord, I can do it by tomorrow. Therefore, so far as my part is concerned, your lordship may let him take his time. Let him take his time.
So you are at liberty to file within tomorrow.
Yes.
And you shall file the reply within 2 weeks after the vacation.
as my lord.
Will it be possible to file within a week after the vacation?
No, my lord, because the university will remain closed. Your lords will appreciate the difficulty.
Um,
I shall, my lord, send it. If it is handed over tomorrow, my lord, I shall send it by tomorrow itself.
Submission the third. Learned counsel appearing on behalf of the appellant submits that he will file the supplementary affidavit along with all the relevant documents within tomorrow and shall provide the copy of the same to learned counsel appearing on behalf of the university. Full stop. Learned counsel appearing on behalf of the university is at liberty to file affidavit in opposition within 2 weeks after the vacation. তাহলে 2 weeks after the vacation হচ্ছে আমি কোথায় দেবো 19 week time 19 week 19 থেকে জুন 19 এর পরে
Clear করে রেখেছি, ওটা university।
20th June. After the exchange of affidavits, the matter is being fixed on 20th June.
June 20, my lord.
Milord, my learned Julius says that on 20th June there is Ratho Jatra. Though I do not find, Milord, there is any
No holidays.
no
here.
holiday.
No holiday.
Very good.
No holiday.
20th June.
On 20th
Yes,
June,
yes.
as mentioned matter.
Yes.
20.
New journey, beginning of new journey for your client.
At a whole file.
দিতে পারছি না, দেখ আমারটা দেবো। না না প্যানেল ওয়েবসাইটে এই এটা কি দিলি? এটা কি আমাদের পয়েন্ট?
I'm appearing for the School Service Commission. I'm being led by Mr. Kishore Datta.
Well, I'm appearing for the appellant as a first order. I appear for the added respondents.
স্যাররা কি অ্যাডেড হয়ে গেছে? স্যাররা অ্যাডেড
Only one thing before the appellants start any argument. The matters are appearing at our instance.
এইটা এফিডেভিটের রিপ্লাই জবাবগুলো তার রিপ্লাই এতে সেই পয়েন্ট ওয়াইজ পয়েন্ট গুলো নেই
ওসিটা দেখে নেবো ওসি যেন না চলে ওসি সাদা যে কি করছে সবার
File affidavit that was not given. SSC.
কোন ম্যাটারটা এই আইটেম 16 সার্ভিস হয়েছিল আমাদের উপরে দেখো তো
আচ্ছা জজ সাহেবের অর্ডারটা এই ফার্স্ট যখন অর্ডার
তুমি বলেছিলেন একটা ম্যাটার সার্ভিস হয়নি পাওয়া যাচ্ছে কত টাকা চেঞ্জ করে আমাদের উপর সার্ভিস হয়েছে
কি
এই অর্ডারটা এটার ফার্স্টে অ্যাডেক্স করা আছে সেকেন্ড এফিডেভিটটা আমরা দিচ্ছি
Items 15 and 16 were not served upon the commission. That is why affidavits could not be given to the concerned advocates. But all the matters we have given them. And in the first matter, that is Rajiv Brahma matter, the appellants have also given a reply.
So this is ready for hearing.
Now, these are those upper primary matters which we were proceeding subject to the directions of the Honorable Court. So from time to time, your lordships had given us certain liberties on the basis of which we have completed the entire exercise. Now the panel and wait list and a list of rejected candidates who were rejected due to various reasons, they're all ready. Those I have brought to court. So all that is now left to be done is to start the counseling, for which these lists are required to be accepted and published in the website of the commission so that we can start the counseling. Your lordships will recall by the judgment dated 20th July 2021, your lordships had set out the guidelines how to proceed. 7 stages were given to if your lordships would kindly see the judgment, the order dated 20th July 2021, what your lordships had initially directed. Internal page 10 of the order. Having heard the parties and anxiously considering the materials placed at this stage, this court by way of an interim order directs as follows. First, the commission shall continue to hold the interviews of all the candidates whose names appear for the personality test. That was done, it has been concluded. After which the second stage, the commission shall conclude the interview, grant marks in the personality test and prepare a panel of the successful interviewees. That has also been done. That is what we have brought today before the court. So the panel, which includes the waiting list also, the panel and the waiting list, that is ready along with a list of the candidates with the reasons why they had to be rejected, why they fell beyond the zone of consideration. And the third is the commission shall not grant appointments from the panel of successful interviewees without the leave of the Honorable Court. So commission actually does not issue appointment letters, it issues the recommendation letters. The board issues the appointment letters. So going by this order, we have now reached the second stage and we are ready to upload the panel and wait list and start calling the candidates for the recommendations. There is actually no bar by this order preventing us from proceeding, but still we have come up before your lordships just to show that we have completed the exercise to this level and at least try to satisfy your lordships that everything has been done properly and correctly so that we can now start the counseling. The 12,000 candidates, more than 12,000 candidates will be employed if this exercise can be done. Schools are suffering since 2016 without teachers.
Dr. Patra, please let us go through our order and then we'll
Lordship.
come back.
Target. এই যে যেহেতু ওই পেপারটা মোটা আছে তো আগের সেটা ফোল্ড করা আছে তো ওই জন্য বেরিয়ে যাচ্ছে নিজে ভাবলে হাফ হাফ
Yes, now please place the directions from fourth.
Order গুলো আছে ইনক্লুড করে
করছিলাম কাগজ থেকে দেখানো ওটা
Yes, internal page 11.
So I had just placed up to the third point where the appointments are to be withheld, but the panels are to be prepared. Panel wait list is to be prepared. Then the full commission shall prepare a clear database of the successful candidates in the personality test, which shall include, among others, the actual statutory marks of the individual candidates in terms of their certificates, qualifications specified by Rule 12 of the 2016 rules, plus the weightage given against each such actual statutory marks, plus the marks obtained in the personality test, and on the basis of such procedure, their individual relative position in the combined merit list. So combined merit list would mean the panel and the wait list together is referred to as a combined merit list. So that is all done. This is the hard copy of the database. Because whatever data is in the database, it has culminated into these panels and wait lists and everything. So everything is now ready.
You are Dr. Patro. These gentlemen feel they have been left out of the weightage from the very beginning. So you were guaranteed to even produce their database as far as we can make out from that. You cannot only give your successful database and the waiting list panel. Kindly see what is recorded as 6th and 7th.
That's a
My lord, all the candidates, their details is in our database. That is undoubtedly there. Now, producing the entire record, that would be.
You have to do something like whatever has been directed by item numbers 4th, 5th, 6th, and 7th. Up to 3rd, you have done. 4,
Yes.
5, 6, and 7 also you have to do. That is all that we want.
May I place and then I will try to respond. The commission shall simultaneously proceed with the redressal mechanism set in place by the Honorable Single Bench.
Which means, in other words, sorry to interrupt you, you have started the process of interview. You have given weightage to candidates and then you have also called them for interview. You were asked to do that.
Yes.
At the same time, side by side, you were asked to also calculate the weightage in the database for those candidates who are appellants before this court. And give them an inspection of both the data, your merit list and their own weightage. And with their original marks, the weightage you calculated. All this exercise you were supposed to do before your interview can be allowed to go through. Kindly see 4th, 5th, 6th, and 7th. Don't only speak of your interview, your merit list, your wait list. Speaks of even their statistics, their weightage of marks, their relative position in the compared to your merit list. And then what is your grievance redressal mechanism found after that?
Yes, our grievance mechanism, it received 18,000 applications, and out of which 15,000 and odd were present, the remaining were absent. Each one was given a separate and individual hearing, and each grievance was redressed by passing a reasoned order, out of which 1,585 and a few others later on, they succeeded in the redressal mechanism. We approached the court with that result on the previous occasion, and your lordships on 30th of September 2022 passed an order allowing us to include those 1,585 candidates in the interview, and we also held their interviews. So the grievance mechanism was done. Possibly the only thing which I do not have in my hand right now, though it is definitely in our computer database in the commission's office, that is a chart showing the exclusive results of the appellants before the court. Only that is possibly what I do not have in my hand right now.
And what does it show? What does the exclusive result show? That they are not they are not qualified to
No,
attend.
that would not be correct. Some of the appellants are in the panel, some of them are in the waiting list, and most of them are definitely, they have been rejected. So the total candidates, not just the appellants, everyone had to be checked. So appellants, the total appellants, I don't know, I have not calculated, maybe 100 or 150 appellants might be before the court, but the entire approximately 1.5 lakh candidates, their credentials had to be checked before we could prepare an interview list. So on the basis of their performance, on the basis of the TET weightage and the academic scores, the interviews have been held. So no injustice has been done, but what is not in my hand today is possibly a special chart which I could have prepared from the database showing the exact position of the candidates. What we had actually thought is that if the court grants the leave to us to upload these, it is not that there is an embargo on us, because the court has allowed us to come up to this stage. So if we upload the panel and the wait list along with the list of rejected candidates who we have, then the candidates, the appellants before the court can automatically see what is there and they can compare for themselves.
Yes.
In addition to that, since there is a direction of the court we will also upload a special chart showing their position vis-a-vis the candidates. That part also we can do. But the grievance here, it is not correct to say that all these stages have not been done. The grievance hearing was a huge exercise, giving personal hearing to 15,000 who were present. 18,000 had applied. It was not.
We got you. So now, Mr. Shanal, what is your further complaint?
Now, further complaint, I tell you, lordships. If your lordships take up the two affidavits they have filed, very short affidavits, your lordships will get it out of that. Now, the very serious grievance now comes up before your lordships that they do not have the OMR seat of TET. There were two TET, my lord, candidates appeared in this process, 2011 and 2015. My lord, according to them, my lord, both the two affidavits are not available to them, my lord, OMR seats. Now, it comes up from the affidavit, my lord, the total merit, my lord, commission first disclosed 12,589 merit listed candidates. They have said. Now, my lord, I will take your lordships to one of the affidavit before that. Now, your lordships kindly consider the first affidavit filed by the commission, because 6th and 7th, before, my lord, they comply with, they have to satisfy how this has happened, your lordships, even before going to the 6th and 7th. Now, your lordships kindly come to the first affidavit affirmed by the commission on 27th March 2023. My lord, at page 4 of that affidavit, paragraph 9. Kindly consider, my lord. After completion of the interviews of all eligible candidates, the commission took up the task to recheck various aspects of each aforesaid 14,052 candidates. My lord, these are the interview listed candidates, 14,052. The said exercise included a complete re-evaluation. Well, kindly consider, this is a selection process. Complete re-evaluation and scrutiny of all relevant documents, including the scanned copies of the original OMRs of the candidates who participated in TET 2015 by the independent agency. My lord, just for a moment, my lord, therefore they are making evaluation of the scanned copies, not the original.
Who are you? Who are you actually?
My lord, I tell you, lordships, there I am appearing for two sets of candidates now.
Who are
the first appeal, which is before your lordships now, on which the first order on 21st January was passed by your lordships. Those are, my lord, candidates who question the very interview list itself. The very interview list. Then this order was passed. So therefore, we are in respect of those, my lord, your lordships, paragraph 6 and 7 of the part of the order. And the other, my lord, application, my lord, the application is moved by my client. That's, my lord, addition of party can 56. These persons, my lord, were in the interview list, but they have been put out of the merit list. My lord, how they got it that they have been put merit list, because of in the paragraph they have said they have been put out of the merit list on the basis of this evaluation of the OMRs. So there are two sorts of candidates, two group of candidates I am addressing your lordships. Now kindly see how the commission has proceeded with, apart from grievance mechanism, I will take your lordships. However, the OMR seats relating to TET 2011 were not scrutinized, as the TET 2011 examination was concluded long back, not just 4 years before. And all candidates have been issued mark sheets and certificates. Both of the candidates have been issued mark sheets. 2015, 2011. After evaluation and scrutiny of the OMR seats of TET 2015, it appeared that there were 3 missing OMRs which could not be freshly evaluated. Further, certain irregularities were detected with regard to AMS of 1463 candidates who went out of zone of the consideration, even from the interview list. The irregularities included, kindly consider now your losses. Caste category mismatch of 2 candidates. Kindly see the mismatch of marks in case of 559 candidates of the 1463 OMR seats, and defaced OMR seats in case of 902 others, along with mismatch, for which 1463 candidates have been treated as ineligible. After removal of the said 1463 eligible candidates, I am now appearing in the by way of addition of party, this 1460 out of some of them. The total number of candidates who successfully appeared in the interview are fit to be included in the final merit list is 12589. The final merit list of the re-evaluation and scrutiny reveals that only 12589 candidates are now eligible to be included in the merit list panel plus waiting list shown below. Now kindly see your lordships, the chart they have shown. Set of candidates successfully appearing in the interview for being included in the merit list, out of which going out of the zone of consideration of the newly re-evaluated marks exceeded TET marks. Can it be done by the selection committee? TET marks have been given in 2015. In the process of selection,
Did you not bring all this before the grievance redressal mechanism?
I tell you, losses, this was before the earlier round of litigation, before this honorable court, by which the entire selection process was cancelled. This honorable court came to the finding re-evaluation of TET cannot be done. Even then they have done it. And this we could not, because this is in the grievance mechanism cell, because this is after the grievance mechanism cell. This comes out from their affidavit. After the complaints regarding grievance in writing made before the authorities.
But weightage has to be given to all the academic scores, including
TET.
Then
your losses TET, suppose I have got 60% marked according to my mark sheets. Their evaluation says now I am 30.
Let them publish that they will not implement that. Let them publish that along with your chart, or you will be in a better position to understand your position.
That's
Instead of arguing on affidavit, let them publish it. You let them publish your chart.
This is, I tell you, losses, kindly consider this. This has been done only in respect of the candidates who are in the interview list.
No, even those persons who are left out of the interview list, they have a separate chart.
No, they have not done re-evaluation in respect of them.
You point it out after the chart is there with you.
Then your losses, if your losses it's commensurate to your losses.
Because this kind of a lecture-oriented discussion is meaning nothing.
I tell you,
if you want to point out to some statistics, they want to publish the interview, publish the waiting list, publish your chart also. Take the hard chart, come back to this court and show us illustratively. This is how the weightage has been done. This is how the interview.
Weightage is one thing, Probably, I am going little deep of it. Can there be any re-evaluation?
So
they have said
on the chart.
They have said they have done. They have said, and they have made a 1460 candidates out of the interview. Can they do it? Re-evaluation, my lord. I have been given mark sheets of 2015. They, my lord, both kindly, my lord, consider this. The effect, my lord, may I place the judgment of the earliest judgment, your lordships? Kindly look at it. They cannot be, my lord, your lordships will get it. My lord, we have filed an reply in the form of affidavit, which, my lord, contains the judgment. Now, kindly consider this. Little bulky, your lordships will find the affidavit. Page
number 50, page number 43.
My lord, it starts at page, my lord, quite longest judgment by which the entire process was cancelled at page 29. My lord, even they say now, my lord, on the basis of the scan copies, there were whitening in the OMR sheet. In the affidavit says, my lord, it starts at page 29.
Page number 43.
It starts at page, running page. 43.
এখান থেকে স্টার্ট হচ্ছে, যে কথা হচ্ছে স্টার্ট হচ্ছে রিএভলিউশনের গল্পটা।
No, ওটা দিয়ে লাভ নেই। Now your losses kindly come to page 45. Now, this is one of an issue. Page 45, the last two lines. Well, it starts with the expression third. The commission cannot now contend that the conduct of TET is a different process and not connected to the present selection process. Rule 12(5) of the 2016 rules give weightage to a TET's candidate marks and makes it clear that TET weightage would have a bearing on a candidate being selected for the merit list as detailed further in Part A of Schedule 3. Therefore, any alteration of the TET marks would directly impact a candidate successfully proceeding from the interview list to the next stage of the merit list under Rule 12(5). Further, no notice or intimation was given to the candidates prior to carrying out that reassessment. Well, they said earlier occasion also the reassessment was carried out. The candidates were also not informed of the result of the reassessment. This assumes important things. Clause 11 of the information brochure published by the Commission for candidates appearing for the test state level teacher eligibility list 2015 specifically states that no request for rechecking, reassessment, re-evaluation, or scrutiny of OMR answer sheets will be entertained, and no correspondence in this regard will be entertained. Well, if this is the conditions of the TET examination, can a selection committee re-evaluate the TET OMR?
It is re-evaluation or granting weightage. What is it?
Well, they have re-evaluated.
Where is evidence of that?
That's your losses, kindly see.
How much did you get in TET and what was the re-evaluation?
Well, marks now, they have said only these candidates have re-evaluated and certain candidates have been put out of zone of consideration. That your losses, Malad, kindly for the time being, I am not placing that judgment. Kindly, Malad, the affidavit your losses looking for page 5 that I was placing of the commission's affidavit, thin affidavit. Kindly look at this. On the basis of cans copies of the OMR sheet, selection committee exercising this, taking exercise. Malad, page 5, Malad, your losses, I was placing, Malad, after 12 lines, the irregularities. This expression start the irregularities. The irregularities included caste category mismatch of 2 candidates. Then your lordship, mismatch of marks in case of 559 of the 1463 OMR sheets. What they are doing, your lordship, therefore, with the mark sheets, they are comparing with the scan copy of the OMR sheets of 2015. Whether this is mismatching. I have my own mark sheets given by the commission. And then your losses defaced OMRs of 902.
Show us one place where this grievance was brought before the redressal mechanism.
Well, I could not. This is after that grievance. After the filing of the grievance concluded, this has come up. And by the very recently by the affidavit. This was not before.
How have we tried to protect you by our order of directing the commission to do all this? Successful panel of interviews. How have you been protected, if at all, by this order where the commission has said these are the following steps, 7 steps required to be taken?
Exactly, my lord. That's my lord. Your lordships have protected us. If your lordships kindly consider this. My lord, the third clause, 6th and 7th. Third, no appointment will be made. My learned friend is pointing out the commission cannot make a appointment. That's true. Commission is making recommendation. Board will issue the appointment. That's not the point. The whole purpose of your lordship's order that unless the exercise is done, you cannot proceed.
So where has it been frustrated by this exercise? Show us exactly.
Kindly your lordship, 6th. At the end of the time period for completing the grievance redressal mechanism, the commission shall produce chart. Malad, here they have frustrated. When the grievance mechanism, Malad, was open, we have made certain allegations in respect of the preparation of the interview list in terms of the earlier order of this honorable court. They were prevented from making reassessment. Now in the affidavit, after the interview is done and so-called merit list prepared, they are disclosing by the two affidavits that they have re-evaluated the OMR seats. How could I do it in the, we could not do it before the grievance mechanism. This is their frustrating. The commission shall produce chart in respect of the aggrieved candidates containing their actual and statutory marks, the weightage granted against each of them under Rule 12 and keeping the space for personality test marks blank, as well as stating any other issue of the particular relevance to the aggrieved candidate. Now pause here for a moment. Why your losses directed them in respect of us to keep the portion blank for personality test, so that your lordships can scrutinize the entire thing. So such the grievance is of such gravity of grievance, your losses directed them to keep it blank. Then 7th, on the next day, the commission shall place before the combined merit list data base of the candidates actually interviewed in terms of the directions given above, as well as the database reflecting the redressal mechanism of the aggrieved candidates before this court for further directions. But here again they are frustrating because we could not make this grievance. Kindly visualize, grievance was available to them, those who were not in the interview list. But what they have done in respect of certain interview list candidates, they have re-evaluated of the OMR 6, 1463, and kept them out of zone of the consideration of the merit list.
What is your second complaint? One is against re-evaluation of OMR of your TET marks.
TET marks.
That is one, the first complaint. What is the second complaint?
Second, I tell you, losses. Kindly consider our first affidavit given, Malad. Just a minute, Malad. This one, no? Just a minute. The first affidavit. I've taken, Malad, after grievance. Oh, no, not this one. Our affidavit. No, it is AR2A of the commission. No, you can open. Now your losses kindly take up one affidavit in reply on behalf of the applicants to their affidavit in opposition. Annex করিস নি না গ্রিভান্সটা আচ্ছা Yeah, I just took the losses. 116. Malad, the bulky one, which was your losses looking for, looking at, your losses kindly have a look at page 116. What was our grievances and how they have dealt with? One of the example. Reply. Your losses kindly page 116.
Question is one, they could not re-evaluate the TET marks.
Exactly, Malad.
That is one grievance. Second grievance.
Second grievance, I tell you, losses. We have raised, Malad, 3-4 Malad complaint before the grievance redressal cell. The first complaint, your lordship, was that increase of academic marks of certain candidates. We have given example. Malad, I can take your losses how they have dealt with. They have not dealt with at all. We have said, your lordships, then certain candidates in the application form did not disclose their training qualification, but subsequently that has been inserted.
You should have actually, the shoes should have been reversed. You should have taken the examination. They should have appeared for the examination. That is how you have understood so much about the process of taking examinations. Why should you be examinees anymore? You should be bold.
I tell you, lordships, system has become so corrupt. One cannot survive in the system. They are doing it. Can your losses visualize a selection committee reevaluate the TET mark sheet or TET OMR sheet?
Yes, that is the question we intend to pose to the board. What is the second? Your academic marks.
Exactly, academic. Your losses kindly consider. Amala, your losses page 116. Page 116 of the bulk, the affidavit, which was little bulky. Now, kindly, Malad, consider the what was the complaint and how they have dealt with it. It's dealt korche kothay, seta page number. Malad, kindly consider page 116. Malad, just the last last paragraph. Upon publication of the interview list dated 21st June 2021 for pure science, medium Bengali, general male and female category, read with disclosure of the marks of the enlisted candidates of the interview list dated 8 July 2021 by the Commission as per the order of the Honorable High Court dated 2nd July, I have come to know the following lesser qualified candidates have been included illegally, arbitrarily, in a malafide way in the interview list purportedly prepared in terms of Rule 12(4) of the recruitment rules. Namely, details of Nitai Mondol as per online application obtained from the website of the Commission. State roll number such and such. General male for MP 10 marks having above 60 marks. For HS 8 marks for having above 50 marks but below 60 marks. For graduation 16 marks for having 50 marks. And BA 10 marks for having above 60% marks. And for TET weightage 27.72 marks for having 69.3% marks. Thus, he is entitled to 71.72 marks in total. Now, let's kindly see. On the contrary, it transpires from the details of Nitai Mondol as published by the Commission on 8 July 2021 that is allotment of statutory marks for HS examination has been illegally enhanced from 8 to 10 marks. For graduation from 16 marks to 20 marks. In utter violation of Rule 12(4) read with Part A of the Schedule 2 of the Recruitment Rules 2016. The 6 marks in his total marks have been wrongly increased and enhanced, and thereby total marks has also been increased and enhanced from 71.72 marks to 77.73 marks. Photocopy of the online application of Nitai Mondol as downloaded from the website of the Commission is enclosed here too and marked as such. How they have dealt with, I will place it to your losses. Well, let me place.
Let us go to Rule 12(4) first.
Rule 12(4) first. Just ball page double. Malad, your losses kindly come to page 101.
Yes.
12(4). Kindly consider. The Central Commission shall prepare and publish in their website an interview list. But this should be it should not be an interview list with all details of the candidates to be called for personality test, category wise, on the basis of merit as mentioned in Part 1 of Schedule 2 in the ratio of 1:1.4. Part 1 of the Schedule 2, your losses will be getting at page, Part 1 of Schedule 2 at page 107. How the marks to be allocated. Now kindly consider Part A, Schedule 2, Madhyamik or its equivalent, full marks 10, 60% above 10, below 50% and above 8, and below 50% 6. HS, +2 stage or pre-university or intermediate university entrance or its equivalent. 10, 60% and above 10, 50% above 8, and 50% above 6. Then bachelor's degree as mentioned under clause 2D of the Rule 2 of the said rules. 20 full marks, 60% above 20, 50% above 18, below 50% 16. So therefore, my lord, we have placed before the Commission in respect of Nitai Mondol that this application according to application.
Now let us compare Nitai Mondal with this once more.
Which one, my lord, your lordship? They are complaint.
Yes.
Your lordship.
The part which goes to Nitai Mondal.
And yes.
Let us compare.
Now your lordships will find page 116. My lord, we have first said the last paragraph general after the expression general mail.
Yes.
Well, we have just quoted what is in the rules. Marks for having 60% and above, 10 marks. For H8, 50% marks, but below 60 he got. For graduation, 60%, 16 marks for having below 50% marks. For B.Ed, 10 for having above 60 marks. For TET weightage, 27.2 marks for 69.3 marks. Thus, Nitai Mondal was entitled to obtain 71.72. This we have calculated on the basis of application disclosed in the website.
And
But what they have done, your lordships kindly see. It transpires from the details of Nitai Mondal as published by the Commission 8 July. His allotment of statutory marks for HS examination has been illegally enhanced from 8 to 10 marks. He was entitled to 8 marks, above 50, below 60. But this has been given 10, as if 60.
Yes.
Then your lordships, for graduation, from 16 marks to 20 marks, in utter violation of Rule 12.4, read with Part A, Schedule 2 of the recruitment rules. He is entitled to 16 because he is below 50, but he has been given 20.
How have they dealt with this in the?
And I am just your lordships, page 130. According to them, they have given very good hearing to us. Page 130. 30, এই এটা কোথায় ওদের অর্ডারটা কই হ্যাঁ রিজেন্ট অর্ডার 159 ভুল পেজ বলবি না 159 মানে order
only in respect to Nitai Mondal.
Malad, I beg your losses.
With respect to Nitai Mondal, how much?
Tell to it at all. Kind of a look. I do not find at least, my lord.
Yes, what is the reason order sheet?
This is page 1. Reason order sheet, I tell you, lordships. Upon perusal of all marks in 10 score, total 10 score, and therefore not qualified. They are saying, I am not qualified. If the others, those who have been qualified illegally, automatically I will be disqualified. Then they do not deal with Nitai Mondal.
Place the reason order.
I tell you, lordships. Had the petitioner Rajiv Brahma, had the representative of the School Service Commission peruse the documents at random, the records of this commission, it appears the petitioner has not uploaded a scanned copy of original mark sheet of MP during online verification process, so he has been declared as rejected. The petitioner submitted that all the relevant documents have been properly uploaded as per order of the commission in time. He also submitted that lesser qualified and untrained candidates have been included in the merit list. He submitted details of the following alleged candidates along with relevant documents. My lord, we gave 2 candidates names who are untrained because untrained are not qualified. This says this. Kindly see. Upon perusal of all, his mark sheet of MP is accepted with 10 score, and his total score is updated in West Bengal Commission portal. After updating, his total mark stands below the relevant cutoff marks. Therefore, he is declared not qualified. Then, regarding untrained candidates in the merit list, the present case records along with all relevant documents are hereby forwarded to the Secretary of the Commission to ascertain the truth of the grievance and for comments to the concerned. Now, kindly see the Secretary's comments at the bottom in handwriting. The petitioner's complaint against 2 candidates has been found no basis after verification. But they do not deal with it. First, Nitai Mondal, they did not disclose how the untrained candidate has been included in the list. I have other grievances. So this is one of the example how they have their grievance mechanism has acted upon our grievances. And there are other grievances, your lordship, the vacancy.
Show us, come to page 161. What is this weightage?
161. Malad, this is your lordships, kindly consider. Malad, this is your lordships in respect of the petitioner Rajiv Brahmo. According to them, this was not uploaded, my Madhyamik mark sheet. But according to me, I uploaded because of your computer glitches. This was not recorded. Ultimately, they accepted, and this is. Malad, kindly see the cutoff marks 75 for Sachans and 73. And therefore, I am rejected. They do not deal with my grievances. That how could you enhance the marks of the candidates? There are other examples, my lord. I'm showing one. They do not deal with that.
Then that is the third category of.
Third category. Now your
What
losses.
is your other? What are your other grievances?
I tell you losses. Other grievances.
We have completed one. We have completed two grievances.
Now your lordships, kindly come to the thin affidavit that was I placing before lordships, affirmed by Rajiv Brahmo, affidavit in reply only, paragraph 7D.
Yes.
Now, may I just read out your lordships? The petitioner appellants also specifically state that the interview list consisting of 1543 candidates was not prepared in accordance with the mandate, letter and spirit in terms of Rule 12.4 of the Rules of 2016.
Which page?
Page Malat 6, paragraph 7, small d. The petitioner appellants also specifically state that the interview list consisting of 15436 candidates was not prepared in accordance with the mandate, letter and spirit in terms of Rules 12.4 of the Rules of 2016, inasmuch as while preparing the interview list category-wise, the Commission included the candidates belonging to other categories, namely SC, ST, OBCA and OBCB, etc., in the list of candidates of general category. And as a result, not only lesser number of general candidates were included in the interview list, but also berth in respect of reserved categories were left blank or kept vacant. Had the interview list for general candidates been prepared with only general category candidates, not only more number of candidates could have come within the zone of consideration of 1:1.4, but also none of the berth in respect of the reserved category would have been left vacant. This act on the part of the Commission has not only synchronized competition amongst eligible available candidates in the open market in accordance with rules, but also constituted violation of Rule 12.4. Malad, the Rule 12.4, if your losses kindly one consider, this is a very serious question now, Malad. Kindly consider page 101. May I just read out the Rule 12, sub-rule 4. This is in regard to preparation of the interview list. The Central Commission shall prepare and publish in their website an interview list with all details of the candidates to be called for personal list, category-wise, on the basis of merit. As category-wise on the basis of merit, as mentioned in Part 4 in Schedule. Therefore, while preparing the merit list, category-wise, means this is general, this is scheduled caste, this is scheduled tribe, this is OBCA, this is OBCB, this is physically handicapped. Can they include on the basis of academic score and TET marks a scheduled caste candidate who have secured higher marks than the general candidate in the category of the interview list of general candidate? The judgment of the Supreme Court says that merit in the respect of general candidates panel to be on the, if any candidate gets ultimately higher marks, he can be included in the panel. But can it be, my lord, adopted or applied in the at the time of preparation of the interview list?
No, we could not follow.
I tell your lordships. What they have done, your lordships, when they are preparing the category-wise interview list, they have included the scheduled caste, scheduled tribe, OBCA and OBC category candidates in the category of general candidates on the basis of purported marks they have secured higher than the general candidates. According to us, this is unconstitutional and violative of Rule 12.4.
Why?
I tell you, losses. Interview list to be prepared category wise.
That is not the legal position as we understand.
This is the legal position at the time of preparation of merit list, not the interview list. Kindly consider.
Prior to interview, the person under the category of OBC or scheduled caste who has achieved higher marks has been included in the general category.
Exactly. Before the interview. In the interview list means those who are going to be interviewed. In that list, in the general category, they have included the candidates of SC, ST, OBC on the basis of they have secured higher marks in the academic qualification. This demolishes the.
Therefore, if you have the inclusion can be only after the final profile.
Exactly. After adding the academic score and the personality test score, not at the stage of the interview.
Correct.
This is our case. This is third case. Now, your lordships, kindly consider, we have narrated how this is the consequences of this in paragraph 7E and paragraph 7F. What are the consequences of it? The consequences is, your lordships, lesser number of general candidates getting called for interview. And the scheduled caste candidate, there is a quota, those quotas remain vacant. This is the consequences. So this is a and inroad on the recruitment of the general category candidates. It can be at the final selection after adding both the marks, academic and score. If someone gets higher than the general candidate, he should maybe scheduled caste, scheduled tribe, OBC, he can certainly be treated as not treated to be considered in the category of general. But for that reason, the total vacancy of the seat of scheduled caste will not diminish. That's the law, as I have understood. That's the settled law. But at the interview stage, then they are getting benefit which was.
Got the point.
Then your losses.
The next point.
Next, your loss. Now, paragraph 7G. At page 8. May I read out page 8? Apart from the above reserve category candidates who had availed of the benefits of relaxation like concession of age, marks, etc., have been treated as unreserved category candidates of merit for inclusion against the vacancies on the ratio of 1:1/4 while preparing the interview list for unreserved category candidates. It is now well settled principle that a reserved category candidate who has availed of the benefits of relaxation, such as concession of age, marks, and academic qualification, etc., cannot migrate or claim to be included in the general or unreserved category candidates, as they are not on the same standard of merit. For the sake of benefit, only one example is cited here. Nasiruddin Biswas, serial number 992, pure science Bengali medium, interview list meant for male, female, and general. He has got the benefit of relaxation. I take your loss at this point because the last judgment of Nirav Kumar of the Supreme Court says that following the earlier judgment also, except Jitendra Kumar comes from UP Uttar Pradesh Allahabad High Court, that if a scheduled caste category candidate availed of the benefit of relaxation like age, marks, or any other concession, he has to be treated right from the beginning as scheduled caste category against the scheduled caste category vacancies. Just because he got higher marks, he cannot be considered against unreserved vacancy. That's the jam that they have again violated. The act itself, OBC A and B, OBC A in our state includes almost 97 to 98% candidates of a particular community. Now, those particular community getting benefit of age relaxation because of OBC A, and your lordships, the other benefits in marks. Now, having availed of that benefit, he has to stick to his own category. That's the OBC, the Reservation Act says. On the basis, the language, your lordships, on the same standard of merit. This expression has been dealt with by the Honorable Supreme Court and said it includes age and marks. So this is not only unconstitutional on this inclusion, but also
in the merit list also, after obtaining,
exactly, yeah, right from
after obtaining higher marks than the
even then he has to stick to his own category because he can't get the two benefits. That's the judgment of the Supreme Court, and the Act says, my lord, on the same standard of merit. Even if he gets avails of the benefit of age relaxation, even then he cannot. Then your losses kindly the next, my lord, this is the fourth. 7H. The petitioner appellants humbly submit that the commission should be directed to open the link in respect of submission of original application.
Mr. Sharna, you were intending to show us the rules.
I beg your lordship.
You were intending to show us the rules.
Oh, that's OBC OBC just OBC reservation at 2012. Well, just a minute, I'm giving a judgment. Give me just time, let me proceed. I will be placing it that. Judgment. Just give me, I will place on this. The act and the judgment of the Supreme Court also. The petitioner appellants humbly submit that the commission should be directed to open the link in respect of submission of the original applications by the respective candidates, inasmuch as in the absence of such link which was available earlier, the petitioner appellants are not in a position to get the details of the candidates of the candidate included in the interview list and the candidates to be included in the panel to be prepared by the commission. The submission of the petitioner is coherent with the rule of transparency and fair play. Lord, I tell you, lordships, in order to make grievances, Lord, we want the application of each other. If I have a grievance against my learned friend's client, whether he was properly selected or not, if my learned friend's client's application I do not get, I cannot. I have to know that they are scored. Equally, my learned friend is entitled to get my application and details. Otherwise, this is in consonance and in coherence with the principle of fair play and transparency. Because some of the applicants we got.
That was not published.
Not published. That was, that portal was open initially before the first judgment of our High Court. We gathered some information. Thereafter, they closed it because they are getting the information. I can get it. How could I make a complaint unless I get it? Like Nitai Mondol, his application we luckily got. We kept it. That's why we can point out to your lordship, this is the illegality they have committed. Unless all the applications we get, we cannot. So, these I am paying, before any further, exercise by your lordships, these portals should be open to all of us. I don't find, any logic.
Which portals?
The application portals. Kindly look at paragraph 7H. The petitioner appellant humbly submit that the commission should be directed to open the link in respect of submission of the original application by the respective candidates, inasmuch as in absence of such link which was available earlier, the petitioner appellants are not in a position to get the details of the candidates included in the interview list. I tell you, lordships, suppose I am not in the interview list, for one set of candidates I am appearing. They have said they have kept interview list 14,000. I require those 14,000 applications in the website. They need not give me the hard copy.
Online application.
This was not done, my lord. Your losses can certainly
on the website. What will you see that weightage given to each of them?
My lord, I tell you, lordships, on the weight, I first see his disclosure of qualifications and percentage of mark. If I get it, I can tally with the interview list.
With the
Interview list, how much marks have been assigned by the allocated by the commission. We get it in respect of Nitai Mondal, we have pointed out. There are others, but not much, because I do not have the access to the system. This requires application ID of that particular candidate. Application ID will be getting, my lord, for the knowing the marks allocated by the commission to the interview listed candidates. We require the application ID of that particular applicant. We can get it only from his own
so
application.
now if we ask the board that let them publish their result and also open the application portal for you. Then you can come back to the court.
My lord, I tell you, lordships, we are at the interview stage. Your lordships probably have gone far. If the interview list goes, what would be this is a futile exercise.
Oh, it is just for the purpose of comparison. Your comparison, you come back.
My lord, your lordships direct them to publish the all.
We are imagining a situation where whether by fits or starts or whatever it is, the process can go forward somewhat.
My lord, I tell you, so far my lord, I should express, my lord.
What we envisage for you, you should be in a position to compare everything at yours before any final step is taken. How can that be ensured?
My lord, I tell you, lordships, kindly consider this. We came up before this court questioning the interview list, very interview list.
Yes.
Now, my lord, I request your lordships, pursuant to your lordship's order, they are proceeded. So, okay, they are proceeded up to the merit list on the basis of that interview list. My only submission, if the interview list goes, the further exercise will be futile. So there is no need to exercise further. My lord, all that I am saying, your lordships, kindly those 14,000 applications to be published in the website and the interview list marks have been given to them, so that we can compare and come up. We have given, my lord, thereafter your lordships have the evaluation of OMRC, my lord, this exercise of power, the reservation policy, all these have to be considered.
On the basis of allotment of marks.
Exactly. And the other very vital point, your lordships, I take your lordships. No, ekhane bolechi to. My lord, kindly consider, my lord, page 119, the continuation of my grievance application. What number paragraph about? 119 নয় তো তাহলে ওটা page 119. My lord, this has been in this respect, my lord, already, my lord, our high court has passed certain orders, but they are not complying with it. Kindly consider this, my lord. Page 119, this is one of our grievance that has not been addressed. My lord, last but 4 paragraphs. In terms of Rule 12.4, has you also got that one? In terms of Rule 12.4 of the Recruitment Rules 2016, the interview list is to be prepared by the Commission on the ratio of 1:14. Clear, your lordships? This presupposes number of vacancies. Otherwise, ratio cannot be ascertained of candidates to be included in the interview list. Well, let me proceed little further. Rule 8.3b, read with Rule 9.3 of the Recruitment Rules 2016, stipulates that final vacancy list has to be published 15 days before the date of publication of the interview list, by including all the vacancies up to 15 days before the date of publication of the interview list on the basis of the report in sub-rule 2 of Rule 2.8 thereof. So therefore, my lord, all these rules conceives that the vacancy list, final vacancy list to be published before the interview list. What was the reason, my lord, of the rule? Rule because suppose your loss is 10,000 vacancies. This is assessed that there are throughout the state 10,000 vacancies. Therefore, my lord, the candidates to be called for 1:1.8 on that basis. What they are doing, my lord, the entire exercise was cancelled. Earlier also they did not publish. So earlier interview list also cancelled by this honorable court. This is a face interview list published on date. The first interview, my lord, this interview list published on 21st June 2021. So, my lord, they have to publish the final vacancy list on the date of 7th June 2021. That they have not published. This is another violation of the rule and the order of this honorable court in the earlier process of litigation. Therefore, how could they arrive at a figure? My lord, advertisement disclose the tentative vacancies, but the rule doesn't, my lord, permit on that basis to be the selection process to be followed. Rule permits that you have to disclose the final vacancy list throughout the state just before publication of the 15 days. That means 7th June of 2021. They have not published. Then how could they prepare the interview list? Because in the meantime, my lord, on the basis of their affidavit, 5,000 vacancies more have fallen vacant. 10,000, more than 10,000. Initially, they came, my lord, and said 5,000. So this has to be included. If this is to be included, my lord, they have called for 14,000. This should be 24,000. How could the interview list to be sustained there? This was the this has to be followed. That was the judgment of the earlier order of this honorable court. I can take your losses to that part of the judgment.
So please come back to your prayer. You want publication of the interview list with publication of
those interview listed candidates' original application in the first applications, so that we can compare with it. And then
with all the original applications
in the website, that would do, man. We don't want hard copies.
Yes, website.
Because we can, Malak, still, if you permit me, I can point out.
No more. Yes, Dr. Patro, my learned brother finds the prayer completely understandable. I also do that. We both feel that, yes, why should you not open up your interview list? The original, the application for website.
With all details and
backup. Original application which my learned friend is talking about, the online application, this was also argued on the last occasion. I had submitted one thing, that is the original online applications, the marks mentioned there, the percentage of marks obtained by the candidates. It is all calculated by the candidates themselves. That is why there is the process of verification. We verify. Sometimes they do miscalculations. On verification, sometimes their marks go up, their marks go down. So the manner in which they are relying on those online applications as to be the final marks of the candidates, and any change is an illegality on our part, that is a very wrong approach coming from their end. Even though they
how do you meet the case of that Nitai Mondal? How do you handle that that which has been
Nitai Mondal's case? I will have to verify whether at all he is in the merit list, whether at all he is of the same category as the candidates, because the grievance hearing was for individual grievances, not for wholesale. Your lordships have seen the amount of grievance they have put into one application, where I'm hearing 15,000 applications.
True.
They are to only correlate to the grievance which is directly affecting the candidate. So I might belong to a particular subject, I might belong to a particular medium of instruction, I might belong to a particular caste category. That is why we have almost 350 different panels, 350 different wait lists. They are to correlate directly. Only then can a grievance be redressed. It cannot be like a wholesale, everything under the sun, each candidate will bring up. Out of 150,000 candidates, one Nitai Mondal, I can come back. I can come back with the specific reply.
Well, not only Nitai Mondal, there are other Nitais also.
Yes, there will be.
Come back with an entire response from pages 116.
There are several Nitais.
Come back with a complete response to pages 116 to 122.
Yes.
Please come back with a precise response to 116 to 122.
116 to 120. Yes, the grievances. Well, may I say only one thing, Miller? Before your lordships, Miller, there are very few petitioners. I have not checked up the numbers, maybe 100 or 100 and odd. Miller, we are dealing with, Miller,
several thousand posts. My lord, the process of grievance redressal, the process of correction of errors have been undertaken. My lord, we have tried to do it as much as possible, I mean, free from error. My lord, there may be one or two errors here and there may be. But my lord, for that, my lord, so many posts, my lord, are being held up. Please consider this, my lord. My lord, under the, my lord, direction of the court, my lord, we have given them the hearing. And my lord, based on that, my lord, now, my lord, we have scrutinized the candidates, done whatever is required to be done, and my lord, we want to publish this. Now, my lord, kindly permit us to publish this. Thereafter, my lord, whatever grievances they have, my lord, that can be taken care of by the court.
Publish what?
The panel that, my lord, we have prepared, my lord, after, my lord, undertaking the
merit list.
Yes.
That will be creating another set of rights. Those people will rush to court and say, now give us appointment.
Yes.
We cannot deal with so many people at the same time.
Yes. But please,
as it is, we are handling whatever mess has been handed over to us to sort out. It was really not our job to sort out this kind of a mess. But we are handling it. This mess was oppositely was supposed to be handled at your end. You framed the rules. You understood the rules. You should have done everything stepwise.
True, my lord. My lord, our contention is, my lord, one or two grievances here and there, my lord, please consider, my lord, whether this should stall, my lord, so many thousand posts or candidates. And the ultimate sufferer are the students.
You should have thought of it.
Yes, my lord, we have.
Board should have thought of it.
Yes, definitely. Definitely, my lord, we should have thought of it. Now, my lord, we have undertaken this, my lord, process. Please allow us to, my lord, publish the merit list.
So what happens to page 116 to 122 after you publish the merit list?
Yes. Now, for example, my lord, please take my page 116. For example.
the SSC, they re-evaluate the OMR sheet. Suppose, my lord, the OMR sheet revolution is not allowed. In the earlier judgment passed by Honorable Justice Mosme Bhattacharya, specific observation about it. My point is that, my lord, they ought to open the online application further, my lord. Why? Suppose, my lord, a candidate, if they want to exercise this OMR sheet re-evaluate, then, my lord, suppose a candidate, my lord, in the TET 2011 got higher marks. Because they have two mark sheet, one is TET 2011 as well as TET 2015. After their TET 2015 marks, they come up with TET 2015 marks. If they re-evaluate and they not give the chance to put the TET 2011 mark, then that person will deprive. So they have to go from the stage again. Their conduct itself.
What do you mean? What do you mean by re-evaluate? What do you mean by re?
Evident, my lord, yes.
Online application is
Lord, may I hand up the ruling that I was referring to on the next stage? I have two copies.
My lord, without interrupting my learned friend, my instructions are that the online applications of the persons who have found place in the merit list today, which I am praying with your lordship to be allowed to be published, all the online applications of these persons are uploaded already.
That is not about online application.
So if these are already uploaded, but what else do the petitioners?
They are saying that they are they are locked. They are not there. They are locked.
My lord, initially 2016.
My chairman is before this court, my lord. He says that it is not locked.
How do we?
Unless
yes. Now, my lord, please consider, my lord, where the
contrary to their stand.
my lord,
How do we know who is correct?
Item number 16.
my lord, when my lord, a public authority, my lord, is saying before the court, my lord, there is a presumption of my lord genuineness in that.
I think before item number 16.
They have no relation. Application ID started. They started with a past state candidate. How they brought back the state process. In their affidavit filed on 24th April, my lord, paragraph 3 stated. In paragraph 9 of the statement, has also stated that on further rechecking of the credential of the candidate.
My lord, item number 16, my lord.
OMS of 1,463 candidates, my lord. So they re-evaluated 1,463 candidates in the selection process.
Yeah.
My lord, I give an example. Suppose, my lord, Kolkata Municipality Corporation, my lord, give an advertisement, they want to recruit group D post. And for that group D post, minimum eligibility criteria is Madhyamik. Can Kolkata Municipality Corporation have that authority? They recheck the Madhyamik mark sheet. They recheck the Madhyamik examination paper. No, not at all. Not only that, my lord. Take my lord.
It will be all for today. We'll just
only one interruption.
My lord, item number 16.
1 minute. Yes.
Item number 16, my lord, I am the affiliate, my lord. No copy of the affidavit has been served upon me. Can you direct him to serve copy?
That's all that you want to say. Something more? Say something more interesting.
My lord, so that I can file the, my lord, the affidavit, an exception, my lord. Otherwise, my lord, the matter will not heard.
One submission, my lord. If your lordship may kindly have a look to page 8 of the affidavit. Please spare me for 1 minute. 1 minute. Page 8, my lord, of the affidavit which my learned friend has placed.
I have placed page 8.
Page 8, my lord, may give some indicator that the petitioners also want that it be published. Please have a look to this, my lord.
Hari Bhimu.
My lord,
One sentence, if your lordship may kindly have.
We'll meet tomorrow at 10:30 for this one.
Right.
Ashok.
my lord, in item number 11, I have two applications for addition of party, my lord. It may be considered, my lord.
সব add হয়ে যাবে।
ওই যা যা আছে আসুন item 7 to 11 যা আছে একসাথে করে heard the parties matter be placed for hearing tomorrow. Mention matter at the first.
My lord, I am not citing the ruling today, my lord. On tomorrow I will.
Tomorrow, whatever time is permissible in the first half. Because there will be there are some mentioned matters, 4 mentioned matters, and 1 more is added today. We'll look into there's a board has an urgency to publish. You want the publication in certain terms. Mr. Shamim, come tomorrow morning and please hand Dr. Patro, ask you, Learned Junior, to hand over whatever affidavits are not handed over. Ask her to look into it.
No, those matters, they have not served their.
Please sort it out among yourselves and see.
Asked them several times, at least send them.
You please coordinate with Dr. Patro and then come back. Yes.
What is those appeals
Public
technically?
media
Because they have
চলে
not
এসছে।
served.
এ ওরটা পেয়ে যায়, ও ওরটা পেয়ে যায়।
Appeal serve করেন
ভাই, আমার সামনে
appeal serve করো ভাই।
কোথায়? এটা আমার থেকে আলাদা করে রাখ ভাই।
কে বলছে?